सो फ्रेंड्स, आज अब हम पढ़ेंगे इस वीडियो में व्हाट इज एलएलपी, द फॉर्मेशन एंड कन्वर्जन ऑफ लिमिटेड लायबिलिटी पार्टनरशिप। तो 2013 में, जैसे मैंने पिछले वीडियो में बताया था, कंपनीज एक्ट 1956 अमेंड किया गया था और उसमें ओपीसी स्मॉल कंपनीज एलएलपीज को रिकॉग्निशन दिया गया था एंड दिस इज हाउ लिमिटेड लायबिलिटी पार्टनरशिप वाज फॉर्म्ड। Because otherwise partnership firms have unlimited liabilities, partners have unlimited liability. Plus, if the partner died in the partnership account, we had to close the account. But here LLP is a perpetual entity. Partner may die, designated partner may leave, partners may join. The account continues forever, right? So we'll just see the features. Briefly we'll discuss. We'll give you an idea. So what we'll do is, why do we need separate form of organization, comparison existing options, who can prefer LLPs, who cannot, incorporation of LLPs, concepts, what are the important concepts, conversions, critical aspects of conversion, and other matters. The slide will give you an overall view what LLP is, right? It's very common and normal nowadays. People are forming this LLP. So why do we need separate form organization? Why a need was felt in Amendment 2013 that we should have LLPs and OPCs? The rationale was that there is no need for a multidisciplinary professional firm. There is restriction on number of partners under section 464, that is 15 case of non-banking and 20 in case of banking, right? So we cannot have more than 50 members or partners in the partnership firms. Big hurdle is the liability of all partners unlimited. Because liability is unlimited, that is the biggest, that is the biggest drawback of that, right? So a need was found. SME, small micro enterprises, cannot cope with the corporate financial rigidity, dividend, capital related party transactions. So SMEs entities, they can form LLPs without having to undergo all the rigidities of paying dividends if the profit is there, capital related party activities, and of course audit and balance sheets. SME cannot cope with the compliance requirements of company. So it's a very small entity, company is a very large entity. SME sector generally does not raise money from public. They don't go to public like private sector companies. Only public limited companies can go to public. So SME sector does not really raise money from the public. So what is LLP? Provisions of Partnership Act not applicable. Provisions of Companies Act excepting winding up not applicable. Except winding up, it's not applicable, right? So we have mix of features of partnership as well as Companies Act in the LLP, Limited Liability Partnership. So comparison with existing options, we have partnership in the first column, particulars, limited liability partnership and companies. Legal entity, no separate entity. LLP is a separate entity, company is a separate entity. Perpetual succession, partnership, it is not applicable. So when the partner dies, we have to close the account after freezing and getting the death certificate of the partner who has died. Succession perpetual is available in case of LLPs and companies account. Liability, partnership unlimited. LLP, companies, it is limited. Does the LLP really have perpetual succession? Question is this. LLP is liable in case of wrongful or omission by the partner in course of business. LLP is not liable if the outsider is aware that partner has no authority to act. Right? Every sentence is very important. If outsider is aware that he has no authority to act and he is acting, so he is not liable. LLP is not liable. Partner is not liable for wrongful act omission of another partner's LLP, which is not there in case of partnership. In case of partnerships, partners are liable for wrongful act and omission. Partners may be personally liable, auditor's liability, right? Partners should indemnify the LLP for any loss caused by his fraud in conduct of the business. So partner has to indemnify in case of any loss. So that partner has to bear the loss in case any action of his causes any loss to the LLP. Comparisons, right? The compliance level partnership, it is low. LLP moderate, company is very high. Audit every quarter, you have to get balance sheets published, audited, right? You have to declare the results. Dividend distribution tax, DDT, not applicable in case of partnership. LLP not applicable. companies it is applicable. Dispute resolution system, it is only available in case of company. Making investment in shares, LLP can go to public, that they can invest in shares. These LLPs, they can buy shares, they can go into equity market, and company can also invest in shares. FDI, foreign direct investment, right? ODI, ECB, external commercial borrowings. Partnership is eligible. LLP, FDI, where there is no sectoral caps conditions, ODI is allowed. Company is eligible. NBFCs, public limited companies, they can form, but LLP and partnership, they cannot form NBFCs. From bankers' point of view, unfavorable partnership, LLP unfavorable, but company is favorable. Who can prefer LLP? Asset holding company, the main company, who forms various subsidiaries. Best for joint venture entities, those who start a joint venture, LLP is the best form to start a joint venture. All partnerships, article of persons with no long-term objectives, right? AOP with long-term objectives. Any company not having bank loans, professional firms, CAS, CS, CWA, right? So they can, association of people. All partnerships oblique AOPs, association of people with long-term objectives. So people can form association in the shape of LLP. Service sector and real estate. Who can go for LLP? Not NGOs, they are not into profit making. Financial investment entities, still RBI recognizes LLP. FDI is not allowed where there are sectoral caps or conditions are there. In corporation, partnership agreement is required to be entered, right? At least two partners, at least two individuals are required to be designated as partners. We call them designated partners. The designated partners, they do all the official work or all the required work for forming LLP with the registrar of companies and all that. At least one of the designated partners should be resident in India. So one designated partner should be resident Indian. So NRI can be there, but one at least should be Indian. So concepts, there are few concepts in LLPs. One is partner, designated partner, contribution, and LLP agreement has to be there, right? So designated partners are those partners who see the legal formalities to be completed before LLP is formed. So they are responsible and accountable to get the legal formalities completed before LLP is formed. Partner is agent of LLP, not of other partners, right? Partner is an agent of LLP, not of other partners. So it's not jointly and severally, right? So it is severally liable. Principle of agency. Agency is a relationship that sits between the principal and the agent. Agent bound to conduct business on the directors of the principal. The agent is who? He is the partner. Agent is bound to conduct business with reasonable skill and diligence. Agent is bound to render proper accounts to its own principal. With agents acts otherwise is liable to make the loss good to the principal. In case of any loss, he has to compensate to the LLP. Agent to compensate principal in case of negligence also, right? Designated partner is a condition similar to officer in default. Contribution is not a capital. Contribution is similar to guarantee. Contribution need not be basis of voting or control. Contribution need not be basis of profit sharing also, right? So it is not designed there what is a profit sharing, what is a guarantee, what is a capital right, voting rights, right? LLP agreement, provisions of the Indian Partnership Act 32 shall not apply to LLP. In the absence of provisions of LLP agreement, of first schedule are applicable, right? Only the first schedule of Indian Partnership Act 1932 is applicable. First schedule is Partnership Act. LLP Act has only 81 sections, 4 schedules, not like Companies Act. No partner shall draw remuneration, no will get salary, right? LLP shall indemnify partners against liabilities incurred in ordinary courses. Each partner shall have one vote in the meeting. No partner can be admitted with consent of all the partners. Decision taken at partners meeting should be minuted within 30 days. There should be minutes noted in a register. New business can be started with consent of all the partners. Partners shall not compete with LLPs. And partners cannot derive any benefit from LLP without consent of the partners. Important aspects of LLP agreement: profit sharing pattern, voting, contribution may not be related. So it's not that if I contribute more, I'll be able to draw more profit from the LLP. Powers of designated partners to be specified. Decision making process to be defined. Exit mechanisms if some partner wants to exit. Dispute resolution. Article of association of public companies can be the basis, right? So it has rules of management. Article of association has rules of management into it. Agreement for family businesses, venture capital undertaking, widely held companies will be different. Contents of LLP agreement: name, registered office, partners, changes in partner, designate partners. So you can see in the slide: management, meeting, votings, partner contributions, profit sharing, books of account, and statutory records and filings, right? So these are basically part of LLP agreement. It is detailedly given in the LLP agreement. Content of LLP agreement: statutory auditors, right, duties of partners, partnership relations, consequences of breach of covenants, title of property, winding up, and general provisions of dispute, waivers, severability, that is jointly and severally, right? So separately, severably, notices, jurisdiction, and savings. The process for incorporation is obtain DIN number, right, to designated partner identification number. Apply in Form 1, enter LLP agreement, submit Form 2, obtain certificate of registration, submit Form 3 within 30 days, process time 15 to 20 days, LLP can be brought into existence. Registration is now decentralized to the respective ROCs. ROCs are Registrar of Companies. All the assets, liabilities of the firm would get vested in LLP. All the partners become partners of LLP. Partnership firm registered with Registrar of Firms stands dissolved in case partnership firm has been converted into LLP, right? So a partnership can be converted into LLP, then partnership firm registered with Registrar of Firms gets dissolved. Partners personally liable for liabilities incurred before conversion. Consent of all creditors is required. Statement of asset liabilities by CA of less than 30 days. Acknowledgement of last income tax returns are there. Conversion of company to LLP. Even a private limited or public limited can be converted into LLP. There should not be any security interest on the assets of the company, right? It should be of free assets should be there. There should not be any charge on it. All the assets and liabilities of the company would get vested in LLP. All shareholders become partners of LLP. So all the shareholders become partners of LLP. Consent of all creditors is required. Statement of assets and liabilities to be jotted down by the chartered accountant should be less than 30 days. Acknowledgement of last income tax returns and company stands dissolved in case company is converted into LLP. The process of conversion is given in your slide. You can note it down later on also. So I won't repeat each and every one. So it's like updating residential status, apply for form. The same we had seen earlier. Conversion in Form 2, in Form 17 or 18. Obtain certificate of conversion, enter LLP agreement within 30 days, submit the Form 3, filing Form 14, right? So these all are centralized with Registrar of Companies. They can go on the website and do all the conversion there also. The critical aspects of conversions kya hai? Equity capital, how will it be taken? Treatment of equity capital, differential voting rights, treatment of professional capital, all these will be taken care in the conversion, right? In the LLP agreement. Stamp duty implications, changes in licenses, government registrations, this will be taken care of. So 7 partners minimum are required, right? Consent of secured creditors, no default in filing of forms, right? The LLP can be converted into company, but minimum 7 partners are required for a public limited company, right? Conversion of LLP into company process. So these are the process given in the slide. So those of you are interested, they can note it down. So INC1, these are available online also. LLP into companies, URC1, INC7, INC22. These are some of the DIR12. These are some of the forms available on online also, and you can apply. The people can apply on online also. So attachment of form URC, just I have given these. So those who are interested much more into it, they can go through this slide. List of partners, list of directors, and affidavits from all partners stating post Registration docs shall be submitted for dissolution, copies of all previous deeds and certificate of incorporation, COI, consent or NOC from security creditors, written consent from majority of members, partners for conversions. Right, you are seeing these are some of the options given when you conversion takes place. So you can note it down from the slide, those who are interested into all that. Right, whether doctrine of ultra vires is applicable. The incorporation document shall state the process business of limited liability partnership. Right, so whether doctrine of ultra vires is applicable in this, we'll let you know. So friends, doctrine of ultra vires means acting beyond powers, right? So in companies it is applicable like a doctrine of ultra vires if the company acts beyond the powers of the director. That act is considered null and void. It does not have any legal sanctity to it. That is called doctrine of ultra vires, right? So questions are there: can LP issue debentures, bonds, converted into company firms, have share capital stock exchanges? Can they list on stock exchanges? Can they invest in incidental businesses also? So unless otherwise stated in agreement, admission, consent of all partners, resignation notice in writing not less than 30 days. Removal, no majority of the partners can expel any partner unless power to do so has been conferred in express agreement between the partners. Right? So designated partners, the same is there. Consent of all partners is required for admission. Notice of 30 days, right? Registrar of registered office unless otherwise stated in agreement. So consent of secured creditors required. Notice of change if they want to change the address, right? This is available here. Contribution increase, no provisions, reduction, withdrawal cannot be done here, right? Voting, one partner, one vote. Profit and loss, equal ratio, irrespective of their contributions, right? Accounting on cash basis, accrual basis, according to double entry system of accounting maintained at registered office. Records have to be preserved for 8 years. Statement of account and solvency statement within 6 months from the end of the year. Form 8 within 30 days. Signed by designated partner of LLP. Approved by each designated partners. Audit is mandatory for LLP having turnover exceeds 40 lakhs in any financial year. So any LLP having turnover excess of 40 lakhs, audit is mandatory. Whose contribution exceeds 25 lakhs in any financial year. LLP which are exempted from audit does not get accounts audited. Statements to be included in statement of account. And solvency by partners to effect that partners acknowledge their responsibility for complying with the requirements of the Act. So auditor, chartered accountant in practice, tenure 1 financial year. So this is all that this is given here. An auditor, if you want to avoid or you want appoint auditor or you want to remove him, all these powers are there. And how to exit lastly. The striking of name of LLP not carrying any business or operations for a period of 2 years or more. The ROC can close the LLP suo motu, means without any notice. If any LLP is not working for 2 years and more, for a period 1 year and more, LLP have made application to registrar for striking of. Practical issues, Form 3 of incorporations, Form 8 and 11 at least once. I think this we have covered. Mostly LLPs. LLP may apply for striking of its own case they want to close down to Form E, Form 24 along with authority, partners, consent. We need consent and copy of latest income tax return, a statement of assets and liabilities, undertaking indemnity bond, form should not be prescribed. So this we have done, right? So this all we covered, limited liability partnership. Now people are forming these LLPs more than company because private limited companies, public limited companies, there are a lot of restrictions for audit and all that. Here the liability statutory obligation is less than companies. Plus partnership liability is unlimited here. So hope this was a grand presentation for LLP. I think basic concept you can jot it down, main points and to start opening. So before you open an account of LLP, you have to keep these points that I have discussed in detail here while opening the account of limited liability partnership, which is a combo of partnership and companies features both combined. Thank you.